And we would like to dive into our main topic for today, that is management of contracted by Sia. I would like to welcome Sia. Sia, can you hear me?
Yes, I can hear you. Thank you.
Thank you very much. Sia is our guest presenter today. Syabonga Makhaye is from South Africa. Management of contractors is the topic that is going to present to us. Sia have got 25 work experience in occupational health and safety, environmental quality, risk manager fields. He has worked in heavy engineering industry, ranging from mines, platinum, ferro-manganese smelters, and steel fabrication, construction, and manufacturing. He is currently running his own consulting firm in safety, health, and environmental quality, and sustainable. And he has also many clients that he have in South Africa and Namibia. He has successfully developed and implemented CQ management system, receiving certification according to ISO 14001, 45001, 29001, and 9001 standard. SIA has experience in dealing with the regulation at all three levels of government, as well as other stakeholders, ranging from organized labor, industry, associated, and public, who have interest or affected by his operation. And without chewing much of our time, I would like to leave this chance to Sia. And Sia, you have the audience.
Thank you very much. I would like to thank ESH Lounge for this opportunity to present this morning. I'm going to share my slide. I hope you can all see me as well. The presentation I'm going to share with you today, and really emphasize the word share, is I say share because it's based on my experience, my knowledge, working as a head of department in terms of SHEQ, but also working as a contractor company in some instances, but also being responsible for contractors. So it's a combination of all those experiences and knowledge that I've gained over the years. I do not claim to be an expert, and I really hope that this session today will allow us to have comments and insights from the various participants this morning. So without further ado, let me get straight to the slides. The topic is contractor and supplier management from an EHS perspective. I downplay Q a little bit because I want us to take Q more from a technical engineering, construction, quantity surveying perspective. So we'll focus on the environmental management, health and safety perspectives this morning. The presentation will take the following format. I appreciate the introduction as well as the safety moment from Tichawana earlier on. It is very pertinent to today's presentation on contractor management. I'll share a remark about why I think management of contractors is critical in all businesses for everybody working in the world, basically. We have seen the shift towards less consolidation of companies, but empowering smaller firms, smaller contractors to come to the fore. And then I will summarize the process by highlighting what I believe are the 5 key steps in contractor management. And then I'll delve into the start, the beginning of it all. It starts with the clients. Now, the clients can be defined in many ways. Could be a funding agency, could be a government department, it could be an organization. The client's responsibilities are going to define how we manage contractors in industry. And then secondly, the use of the word high risk activities. There I am referring to what I believe is the context, the basis for engaging contractors or selecting contractors. Some people call high risk activities critical tasks, those tasks that are prone to risk and possible incidents or EHS events. It is not a conclusive list by any means, but it's a start. Based on that list of activities, I then propose that clients or owners of companies then should request or demand that the contractor companies, prior to starting work, submits a dossier or a file that proposes how the contracting company is going to manage EHS requirements or comply with the client's EHS requirements on that file. And the client obviously must review, comment, and approve or not approve that particular file. Then the stages of contractor management starts with the planning phase. Planning at conceptual stage by the client or the developer. And then they go into how they appoint the contractor companies and how they manage the contractors during the execution of the job or the project, or even a maintenance call out. Then I will add in a legal framework that helps one to manage contractors effectively. Now, this is obviously based on a South African context or perspective, and I welcome comments from colleagues from around SADC on that particular one. I will then conclude my slide and then open the floor for any further comments, insights, or questions, and then hand over back to ESH admin to close the session. I think it may be wise that if one has a comment as I go through my slides, they either stop me or write on the chat line, and the administrator will help us to address those comments and questions. I'm not sure that everybody can see this particular slide in full. So my opening remark is basically saying, as a lesson for all of us, that should we have a contract with a questionable performance record in terms of SHAC, that coupled with inadequate contractors' insurance in terms of potential for compensation of injuries and diseases, as well as your own inadequate attention or focus on the contractor, you may end up with an inadequate SHAC risk management system for that particular job. Now, remember, we use contractors for short-term duration maintenance work, long-term projects, some from greenfield, developing a mall, developing an office block, laying a railway line. So if your systems are not including the contractors properly, you may have a number of EHS events. And I use the word EHS events to mean incidents that may range from injuries on duty, multiple fatalities, but also to actual structural collapses or environmental damage, as we've seen in the petrochemicals and natural gas industries, where ship or tankers run aground and causing ecological damage. But because you have been the primary client contracting the company that has caused the events, your liability increases in terms of the costs of cleanup, rehabilitation, managing the incidents, as well as obtaining a negative reputation in the industry because you have failed to bring in the contractors to comply to your high level of standards, which may be influenced by your ISO systems, etc. So this is the first point I would like to emphasize. And then if I summarize the process, now one can use different words, 5 steps of the contractor management process, but I think we'll all agree that it needs to start as early as possible. The moment a developer or a funding agency or a government department decides to initiate an infrastructure project or initiate maintenance task, the mines close in winter to do maintenance. The moment you plan the job, decide which contractors, which functions are going to be outsourced, and how are you going to involve the various contractors coming in with different skills and disciplines, obviously. So you need to plan the involvement of contractors as early as possible at conceptual stage or design stage. And then you need to start the process of sourcing them by pre-qualifying various contractors and deciding which one is best suited to your SHE culture or EHS culture and has the competencies and the track record to do the work in your interest safely, within time and within costs. Then once you've decided on a particular contractor or contractor companies, because at times you may involve more than one, you need to appoint them. And as said earlier on by Teacher Warner, get them on board your systems or your culture by inducting them. This is now the onboarding stage. Obviously, after you verified their bona fides in terms of competencies, insurances, etc. Then once they are on your site, you need to manage them. How do they execute the job you've assigned them? And your EHS department or SHE department also needs to ensure that they continuously conduct inspections on the contractors as they do the task, and not wait till the end or wait till an incident happens. And more importantly, if it's a long-term contract or job, we need to do a fully fledged audit because they're part of your system now, and provide written reports and mitigatory measures to improve or to ensure compliance by the contractor. Because their failure to comply will affect your ultimate project and even your certification if you are a certified company. The last step is that you don't just tell the contractors to pack their tools and leave site, but you need to provide proper closure or closing remarks to them, and ideally a report and feedback about how they've performed on your site or on the particular job. Ideally, this should be in a written format, both for your interests in the future if we need to use these contractors, or if we intend not to use them by blacklisting them for the industry. But they also will need that written report or feedback for them to tender for future jobs from the previous task that you had assigned them. So those 5 steps, I think, summarize how contractors get involved with clients in some form or another. Now, if I pause and talk about the planning stage, as I said, this should happen on the clients or the project management companies' conceptual stage when they plan the job, plan the infrastructure project, or plan the maintenance work to be done. And ideally, they should have an existing procedure of how do we engage contractors in our company or in our government department or as parts of our property developing what's the word I'm looking for, plans, 3 to 5 year plans that the funding managers may have. Such a procedure should ideally be documented, okay, and should address both contractors and suppliers. It should define the EHS requirements that need to be complied with throughout the sourcing process. That from the stage when you initiate a purchase request, so you know you need engineers, or you need builders, you need welders, or you need specific engineering firms to come on board you issue a request for quotation, you do preparatory work within your own company in terms of the paperwork you need, the date and times as to when you need a particular discipline of contractors to come through, and you schedule them up accordingly. And then you select the various suppliers and contractors. Some you may have used before, and they may be in your database, so it may be easier to look at that pool, but some may be new to you. And then some may be not necessarily forced, but they may be recommended to you by either the government department for social development or by, again, the people who have the carrying the purse strings to say you must select from this pool or must select from the local area where you are building a particular or conducting a particular project. When you issue a PO or a purchasing order, again, there needs to be a statement that talks to contractor management during execution of the job all the way to the end of the contract. This is over and above the commercial agreements that you may have when you engage with third-party companies. A specific procedure for managing contractors and suppliers makes life easier for the companies and for the developers out there in the market. Now, with regards to suppliers, suppliers may come to deliver material, some may be courier companies. And in my experience, not all of them are meant to undertake physical work on your site. And if that's the case, then you may have limited requirements for them on the procedure. Mainly the health and safety agreement, which also includes your security requirements. They need to know what you require from them if they're coming to your site, that they need to be have valid driver's licenses, their vehicles must be roadworthy, and that you may test them, screen them for COVID, test them for intoxication, adhere to your security requirements, adhere to your parking requirements, etc. And then in South Africa, there is a great push to ensure that any supplier and contractor also plays a role in supporting the company's development charter or commitments to empower local smaller and medium enterprises. So they need to commit to this and sign off and return it. But should it happen that for whatever reason, the supplier is now required to perform physical work on company premises, such a contractor or such a supplier rather must be treated as a contractor, and therefore the full procedure or some aspects of the procedure may apply. Because you may have a supplier delivering material on your site and their car breaks down and they need to fix it on your site, then things change. You need to apply your EHS requirements as they fix or work on their vehicle or equipment on your site. Or you may decide that you don't allow them to conduct any work. They need to take the vehicle out of your site and fix it remotely or away from your premises to avoid any occurrences that may jeopardize your relationship with the supplier. I mentioned earlier on that for me, the best context for, managing the contractors will be really find activities that trigger why you need to be adamant that the contractors comply with a stringent procedure. And I've listed high risk activities on this slide. As I said earlier on, some of you may refer to these as critical tasks. The list is not conclusive, but if one is to conduct work on your site that requires lockout and tagout, or LOTO, as some may call it, this is a high-risk activity. In this case, I'm looking at people working on pipelines, either carrying chemicals or carrying fuel. If they need to do maintenance work on such, they need to lock out and take out and ensure that they've purged the pipes. So it's a high-risk activity. Work that involves interference with moving sites or rail vehicles, for example, in the ports, also in the rail sidings. We have a number of vehicles moving to and fro in the site. And if these are not managed properly, you may find that there's a high risk of incidents because of poor management or of people not adhering to the rules. Work that involves a single person working on their own is not encouraged in most companies because there is a higher risk of a person being exposed or falling or having an attack without anybody there to see them. And therefore, people working alone is not encouraged. If it has to happen, it's deemed to be high risk activity. The person needs to either have a video watching them or have an assistant to be with them. The other activity that is also of risk is people working at height. I have not put in a particular height here, restriction of 2 meters or 1.5 meters, but it's best to look at, does this work has a potential to cause a fall? Is there a risk of falling? No matter how high a person may be falling, if they fall from 0.5 meters and break their ankle, it could be deemed to be a high risk activity. Lifting operations where you are using cranes, etc., are higher risk. Hot works where there's gas welding, also working in explosive atmospheres is deemed to be high risk. Definitely working with electricity, either power lines or working on trains and machinery that have got electrical power on them is deemed to be high risk. Confined spaces, I think we all know what those are, also poses a higher risk. So you need to, again, make sure that there's a procedure because you may involve a third party or a contractor who is not, who may be familiar with their technical task, but may not have the correct procedures to do it safely in your particular workspace. Erection, modification, and dismantling of scaffolds, and this may talk to working at height or lifting operations. It's also deemed to be high risk activity if not done properly. Excavation, you all know about the risk of fall of ground or people being covered by soil if it's not made safe. Radiation in the laboratories, also deemed to be high risk. And work in water or working in a vessel in water or aquatic works is also deemed to be high risk. In general, installing, servicing, and operating machines is also deemed to be a high risk activity. And based on this context, I then propose that you need to ask as a client that the company you are engaging with, asked to conduct any of the listed activities, submits to you a file that contains how they intend to carry out the job in a safe manner without impact on the environment and risk to the employee's health. In other words, they must provide to you a file, a dossier, as early as possible before you appoint them. So you can go through it and decide if these guys are competent, they've got a good check system and a safety culture to conduct the work. Now, I call that dossier an EHS file, which is common in South Africa. That's what we call it, a safety file or an EHS file. And it may contain some and more of the following items. It's quite a long list, and you are welcome to comment if it's not applicable in your countries or particular sectors. But for example, if it's a construction activity, there is a need for the contractor to notify the Department of Labor, where applicable, that they are about to commence on a construction activity, and the Department of Labor inspector gives permission for the work to commence after assessing the site, obviously, and checking all other requirements. The letter of good standing, this is an annual record that a contractor company needs to provide to you to assure you that they have sufficient insurance and funds to cater for injuries on duty of their employees on your site. And if it should be causing incapacity or somebody loses a tip of their finger or can't work anymore, they can compensate adequately for such injuries as well as diseases. So this limits your exposure from contractors. Professional indemnity insurance relates to really the technical aspects of conducting work in terms of quality of work being done. Should there be claims? Should there be a need to repeat the work? Are they covered? Can they redo the work without failing to respond to claims, either from the client or from yourselves or from the public for that matter? On the file, once they've decided on the team that's going to be assigned to your work site, they need to tell you in advance who are those employees by providing identity documents. And if they are expatriates or working as foreigners in a new country, they need to assure you that they've got work permits to be in that country to work. This applies to in the Middle East, to South Africa and other countries where one may go as an expatriate. The next of kin details may be there in a summary fashion because I believe the human resources department may contain more of these. In case something happens to the employee, you will know whom to contact to inform them about their family members being involved in an incident or, Lord forbid, in a fatality. The file also should tell you in advance the team that's going to come in to your site, providing an organogram, listing the roles and responsibilities of the team, as well as their technical proof of competency that are coming from valid institutions and also have dates to indicate they are still valid. In the case of licenses to operate machinery, there are expiry dates. Even for first aiders, there are expiry dates. So we need to ensure that they can inform you in advance that you have the following team of engineers, technicians that have valid certificates, and they will not expire before the project ends. In South Africa, we also add in legal appointment letters. Now, this one relates to duties prescribed by various laws in South Africa. So, for example, you might have to indicate who is your first aider, but also need to indicate who is the person responsible for general machinery operation, as well as to the supervisor of the contractor team that's coming to your site. And linked to this is the evidence that the person has been trained, they understand their legal obligations as they are appointed, and they have signed and accepted that appointment letter. Additional item that may be on the file is proof of induction from their own company. And earlier on, we did get from Chawana the need to now add in COVID-19 awareness. So before they even get to your own site's awareness or information, they themselves as a company need to have informed their employees about COVID-19 awareness and how to manage that risk. The SHE policy and the baseline assessment of risk and the SHE spec will come from the client itself, telling the contractor that the work you're going to do has got the following potential risks, and the contractor then develops a method statement that talks to their particular discipline, if they're coming to lay a plan for you or to build a mold for you or to cement or lay bricks. They need to detail how they're going to conduct their activity, their work procedures, as well as indicating the potential risks of their job and how they're going to manage those risks and mitigate against them. Most contractors also bring in their own tools and equipment. So they need to, in advance, list those in a register that your security company will check, and also ensure that those tools and equipment are safe to be used. They've been maintained, they have been assessed and inspected and can be used. But also, as they are on your site, they need to indicate that they have a template or a form that they're going to use to conduct inspections on their tools and equipment as they work on your site. Personal protective equipment is also a key one. They need to tell you in advance if they are using special equipment, from gas meters to your hearing protection devices, as well as clothing, your overalls that are specific to the nature of the job. So if a guy is working in a flame or high temperature environment, they need to have a flame retardant overall, as compared to a guy working in the laboratory, you may have to have an overall that is it's got chemical proof or will avoid acid proof to them. So it's important to ensure that the PPE is associated with the risk of the job to be done. And also proof that the employees have been issued with the PPE and the clothing at no cost to them, and they've signed for the PPE, and they have a duty to ensure that they don't abuse the PPE, the tools or the equipment and the clothing. I'm going to finish up on the EHS file or the dossier by listing some other items like the toolbox talks, as we had earlier on. They also, as a contractor company, need to demonstrate to you that they do conduct awareness amongst their employees, and also intend to carry on doing so when they're on your site on a daily basis to discuss the tasks to be done on that particular day and highlight the risks or hazards for the day, and the employees sign that they've been part of the daily talk or toolbox talk and they are aware. So should something happen to the employee, they can't claim that they were not informed of the job to be done or the risk associated with the day's job. Equipment, I've mentioned earlier on that they need to have indicated on each piece of equipment a safe workload, so no one abuses that, as well as proof that they've been calibrated and can work safely. Should they be using chemicals on your site, each chemical must be accompanied by a material safety data sheet that is close to the work where the chemical is being, sites where the chemical is being used, and the employees have been made aware of what to do should there be an incident involving the chemical. For example, would they be able to wash the chemical off one's eyes, or will they need to treat the incident differently before calling the ambulance, etc. If they work at height, they need to be aware of the fall protection plan and rescue, as well as the risks associated with that. So where it's applicable, the plan must be part of the file that's submitted to you as a client prior to the guys starting work on your site. They also need to have amongst their team members identifiable responders from first aiders, firefighters, etc., as well as the procedure for managing emergencies amongst themselves. But when they come to your site, this may be superseded by your internal emergency procedure and response plan. But at least they should have basic understanding of how to do during an emergency. So all of these items should be part of the dossier or file submitted in advance to you as a client as you assess and pre-qualify the contractors before you appoint them to your site. I'm missing the headline there. Are there any questions or comments before I carry on? If not, I'm now going to talk about the duties of the client in terms of contractor management. Now, as I said earlier on, the client may be the project management company or engineers that have been asked to manage the project, or it could be an ongoing entity like a mine that is calling contractors to come and do maintenance or repair work on their site or to do expansions. So the first thing they need to do is to be clear within themselves about the work to be done. They need to document the scope that they will issue to the contractor. So you are going to do A, B, C, but excluding D and E because it's going to be done by a different entity or different contractor. They should also indicate the basic risks that are linked to the scope of work to be done by informing the contractor of the intended work. And if there are additional site health and safety specifications, they need to document those and issue them to the contractors in advance, so the contracting company can decide whether they can actually meet these requirements as they are included in the tender document when one issues the request for proposals or for quotations to the contractors in the market. They also need to ensure that the potential contractors have made adequate provisions for the costs of health and safety measures. Besides the financial resources, they also need to indicate that they've got the appropriate people in terms of competencies and other resources to carry out the work safely. Now, if a client has got more than one contractor coming to work on their site, either at the same time or in the same area, or even scheduled differently, you need to take reasonable steps to ensure that there is cooperation amongst all the contractors. You may appoint a principal contractor and allow them to bring in subcontractors under their wing. But your responsibility as a client is not removed from ensuring cooperation amongst all contractors. They should not work over each other and work against each other for any other reason. That responsibility stays and remains with the client. And the best way of doing this is to initiate contractor safety meetings, either weekly or monthly, where you address issues of contractors interacting and cooperating amongst themselves. I'm continuing with the client's responsibilities here, because at times the client may be not on site. It may not be a mining house or a mining company or even an operating firm that runs the mall or an office block. It may be a funding agent or a management company that is a bit removed from the technical aspects of the job. They are in South Africa at least allowed to appoint an agent to act on their behalf in terms of health and safety. But this does not derogate or remove them from the obligations of ensuring that the work is done in a responsible manner from health and safety, nor does it derogate or remove them from their liabilities once they've appointed a competent company or a person whom we refer to as an agent to act on their behalf. The agents in South Africa are called, especially in construction industry, the construction health and safety agents. They are expected to manage health and safety on the client's behalf on the construction site, and they may have health and safety managers, officers, etc. They need to be independent of the construction company. They work or are the eyes and ears of the client. And as I said, the client may be a bank, may be a funding agent, may be a government department that is not on site. So they need to be independent of the project or construction company on the site. They are required to be registered with the statutory body approved by the Chief Inspector in South Africa as qualified to perform the required functions. We have a council in South Africa called the South African Council for the Project Management and Construction Professions, and that is where the agents are assessed and then denoted as being competent to manage health and safety on construction sites. Now, the next important stage is we have the procedure, but how to actually apply it when you appoint the contractors to come on board and help you execute the project. This ideally should be documented on the procedure, and it should be utilized at the tender stage. We call for proposals, and there should be a person in charge from a client point of view that is going to call for the tenders, communicate the ESH requirements, include them in the RFP or request for proposals to say, we as, I'm going to use a company known to most of us, Anglo American, have got the following ESH requirements to all contractors coming to work for us. And then they receive the proposals from the contractors, and the client representative or person responsible to review the received bids assesses the contractor's proposals or quotations and checks that they comply with the stipulated EHS requirements. And then such terms and conditions of the commercial contract placed with the contractors must also include the EHS requirements. So what I'm saying here is that the EHS requirements for managing contractors mustn't be standalone, mustn't be on their own. Even the commercial contract must have a clause that states that for any contractor company working for or on our behalf, there are EHS requirements stipulated in procedure XX of the particular company. So we close the gap between commercial agreements and EHS requirements. Even for suppliers who may not be critical as contractors, we need to include EHS requirements applicable to their commercial contract or commercial agreement. In some cases, you might find that you as a client, you battle to find a qualifying qualifying contractor. The EHS department may come back and say, we do not recommend company A as a contractor for this particular job. But if the senior managers decide that we can't find any other, they are it's called a single source company. There is no other, all others are involved. Again, in the mining industry and smelters, you might find that in winter, when power is cheap, most companies that go and do maintenance are involved. So you better to find one that is fully compliant. You may then decide to take one that is new or developing. You appoint them, but you add in an addendum to say this particular contractor doesn't meet all our requirements, but they have room to improve, and we're going to assist them. Then you develop a contractor EHS improvement plan that gets amended, that gets implemented and added to the contract. The main thing there is that you need to indicate the reasons on paper. Why did you choose this particular contractor, even though they did not meet all the requirements? You then implement the plan, you approve them, but you request your EHS department or your engineers to assist them in complying, and you may need to focus on these particular contractors on a daily basis because you have taken them at risk basically, but you are helping them to develop for future work. So once you have received the various proposals, you need to decide, or based on the file, whether you recommend to the project manager or sourcing department that you approve the particular contractor, or you do not approve the contractor. That now is the stake to say they can come to be part of our team for the project. You need to ensure that they've declared in terms of COVID-19 health risk protocols, that they haven't been recently exposed to COVID-19 or have had COVID cases. And if they have done so, you need to take a view about how you go forward with them. Ask that they have screening pre-site establishments before they come to your site, or their employees after the medicals also need to be assessed for COVID-19 potential risks. Now, various countries and various companies have got different ways of managing COVID-19 health risks, but these need to be clear in terms of how you mitigate COVID-19 on your site and in your company. Some companies do daily screening in terms of temperatures. Some companies ask delivery suppliers to confirm that they are not exposed, have not been exposed to COVID-19. But of importance here is that you need to implement the procedure for COVID-19, but also ask the contractors, how will they manage a potential or an actual positive case on site, such that business can continue and your HR department and the Department of Health is involved. Because as you all know, COVID-19 is a communicable disease. So it takes away the need for confidentiality in view of managing potential health risks to others. It needs to be communicated that a person A has had COVID or has died of COVID, and then the site may be stopped and cleaned or sanitized, as they call it. So this is an addition now to EHS requirements from a health perspective, COVID-19, which will be with us for some time. So we've now assessed the file. You are happy with their competency and their records. And if you need to, you may even go to their previous clients or ask for referral letters. And then you get them on board and they go through the induction and they now are to execute the job on site. Before they start, you yourself as a client, you need to have somebody from a operational level who understand the job that the contractor is going to do, to be responsible for them, to supervise them. It should not just be the EHS department. An engineer or a technician needs to be responsible for the particular contractor. They need to develop a risk control plan now that they understand the site, they understand the risks, they understand the scope of work. And the EHS department and the technical supervisor approves the contractor's risk control plan and holds them to account against that. And the employees of the contracting company needs to be informed about the risk management plan and sign off that they are aware of the risks and the various mitigatory measures to minimize or eliminate the risks. From your perspective as a client, as said earlier on, you need to have trained them on your EHS requirements prior to them starting work. And if you need to manage them carefully and focusing on them, you need to initiate or have established EHS meetings for contractors together with the various supervisors so that they have a platform in which they can air their frustrations if there are any, or their fears, but also where you need to and can share how they are performing on site against EHS requirements. And also, most importantly, share lessons from incidents, whether be they from a particular site or from within your organization or from the general industry. Lessons to be learned to avoid recurrence of incidents such as injuries on duty, fatalities, or collapses of structures. As mentioned earlier on, you need to inspect your contractors regularly. And if it's a long-term project, you ask your construction health and safety agent or the Department of Health and Safety to conduct audits on the contractor so that you can recommend them for future use or not, as well as updating their approval for other people to use in the future. When technical qualifications are required for activities such as scaffolding, electrical work, lifting operations, etc., you need to ensure that the appropriately competent agent or client representatives assesses that and do not rely on the EHS department only, but get an engineer to help with the particular audit or inspection. If you have more than one contractor, a planning meeting needs to be held daily, if not weekly, to ensure that the multiple subcontractors on site or concurrent activities are not affecting each other and posing additional risks to work by a particular company or even the schedule of the job at hand. Now I'm going to pause and reflect on the legislative framework in South Africa that assists in managing contractors effectively. It does require and it does pose a lot of responsibilities and liabilities for clients, as well as for EHS departments, but also for the contractors themselves. And I'm going to start with the common phrase from our legal colleagues. They always tell us that ignorance is not defense. The same principle applies in this case when you manage contractors. Both you as a client, as a managing firm, and as a contractor, you cannot claim that you were not aware or you did not know. The first slide talks of or discusses health and safety legislation mainly. And I've got numbers there, 1, 2, and 3 towards the end. But the first one is the definition of an employer. Now, in South Africa, the employer is defined from employer-employee relations through the Labor Relations Act. So it basically says that an employer includes contractors, companies themselves, includes a person or an entity that is appointing someone to conduct work and will reward them in some form or another. It also includes the construction health and safety agents, because these may be companies themselves with employees that are assigned to assist companies or contractors. But in South Africa, we've been trying to get rid of hiring agents, or what we called labor brokers. Those were always excluded from the the definition of employers. So if you employ people from an agent, the moment they are on your site, you are the employer and not the hiring agent from whom you got the various general laborers or technicians. And then the South African Occupational Health and Safety Act, Section 8 thereof, places an overriding obligation upon the employer to ensure that employees, including contractors, are able to work safely and in an environment which is not harmful to their health. I'm going to pause here because with regards to health, there's a new issue with COVID-19, which is posing a risk to many people. And later on, we'll talk about the Constitution, which says one has a right to choose not to be vaccinated or to be vaccinated. And you may find that the OSH Act says you need to be working in a healthy environment, but if somebody chooses not to be vaccinated, it may pose a challenge for the employer to say, now you are bringing in a potential risk to other people on site if you have been exposed to the virus. Nevertheless, the Health and Safety Act then requires that each company, which is a legal entity, has a person that is representing it. This is through section 16.1, and it asks for a chief executive officer or a managing director to be that prescribed person to represent the company. And obviously the CEO can't be in all the operations, in all the sites, and is therefore allowed to appoint assistants to help him ensure health and safety within the company and all its operations. These are subordinate managers, operational directors, etc. But perhaps of interest to us is section 37.1 of the same act, which deals with the deeds or actions. They use the legal term acts, but I'm going to interpret it actions or deeds or failures or omissions by employees or contractors. In the legal term, they call contractors mandatories. So if a person does something or fails to do something that may be resulting in an offense against the employer. So if someone is supposed to switch off or put in a lock to prevent power from flowing through before maintenance work starts, that person has omitted to do their job, right? But similarly, if somebody does something without authorization, they switch on the power and they have no authority to do so, and that may cause an offense because somebody gets injured, an offense against the employer. The employer will be deemed liable unless the employer can prove in court that they've put in place all reasonable steps to avoid such an unauthorized act or a failure by an employee or a contractor to do what they're supposed to do. And to assist the employers, the OSH Act provides in the second section of 37 the health and safety agreement. It says the employer can put in place a health and safety agreement between itself, the client, and the contractor to effectively limit instructions to contract employees to be issued by their direct managers. So in other words, the client allows the contracting company to issue instructions to their employees and avoid confusion. But in most instances where there's been serious incidents or multiple fatalities, one finds that this particular section is limited in defense of the client. They use the term reasonable and practicable at times, and some lawyers find ways around this particular defense to say, no, you as the client should have done more than what is required. And the lawyer always argues to say, this was reasonable and practical. So it is still a shaky ground in terms of defense in courts. But best practice tells us you need to have a health and safety agreement with your contractor to minimize and limit the liability that may come from an unlawful act by contract employees. From the mining perspective, there is a separate act, the Mine Health and Safety Act of 1996. And this one requires the employer to ensure that employees, including contractors, are able to perform work in a manner that will not harm their health. Similarly to the OSH Act, it also prescribes the appointment of a person to represent the legal entity of the company, a CEO to represent the employer. However, in contrast to the Occupational Health and Safety Act, the employer, for health and safety purposes, in respect of work being performed on an area over which a mining right has been granted in terms of the Mineral and Petroleum Resources Development Act, in other words, a mining license, is defined as the holder or owner of the mining license or the rights. I'm going to explain this differently. You may find that a wealthy person or an investment company applies to extract a mineral or applies to extract petrochemicals or natural gas, but doesn't do it itself, but appoints a secondary company to conduct the mining on their behalf. So that company that conducts the mining or the extraction, according to the Mine Health and Safety Act, is not the employer. They are a contractor. The person holding the right, the wealthy individual or the fund manager or the bank that holds the mining right, is deemed to be the employer. So therefore, the liability doesn't end with the company that's been contracted to conduct the mining or to extract the mineral, but can go all the way to the individuals or the bank or the pension fund that holds the mining license as the employer. So the liability extends all the way to whoever holds the mining license, as well as the contracting company should something go wrong. Apart from the Health and Safety Act and the Mine Health and Safety Act in South Africa, where there's been developments over the years, all the way up to 2014, to develop specific regulations for construction, because it's deemed to be one developing country, and it's deemed to be one of the higher risk sectors in South Africa due to the nature, perhaps at times, of people not complying with the laws. So they defined these regulations to effectively manage construction activities better. It is part of the main Health and Safety Act. It's a regulation revised in 2014, and it's applicable to all persons involved in construction work. It does define construction work, and I can go through that later on, but construction work varies from maintenance to demolition, except it excludes work in your house or in a single-story building being developed for residential areas. But if it's a block of flats, that is deemed to be construction. Even though it may exclude work at your own house or a single-story building, the Occupational Health and Safety Act still applies to you as the owner of that particular house, in terms of the people you involve, your gardener, your helper, your maid, or any other general laborers you may ask to come and build paving or an extension to your house, should something happen. The same regulations also prescribe the need to notify the Department of Labor prior to commencement of construction work, and defines the duties of the client, the designer, and the contractors, as well as defining the processes for managing and supervision of construction. It expects the client to have competent individuals managing the construction work. It expects or prescribes the construction or contractor companies to have construction managers responsible and responsible for construction work. It also assists in assessing the various risks for construction and how those should be documented, communicated, revised as things change, etc. It goes all the way to including how construction vehicles should be used, demarcated, serviced, as well as operated, and includes general housekeeping on the site, and even prescribes how many facilities for women, for men should be available to the construction teams or crews, as well as eating houses, etc. So there are very detailed construction regulations that are trying to stem or to stop incidents that are coming through construction or development activities in our country and in the sector. Going forward with the environmental legislation in South Africa, I'm using this slide really to summarize the context of environmental laws applicable to contractors in South Africa. And the first step in terms of this hierarchy is that there is the Constitution of South Africa, which provides a right to all persons in South Africa to a safe environment that does not pose a risk to their health, and also safeguards the environment. And thereafter, there is the framework, which is the NEMA, National Environmental Management Act, which is the overall framework for all environmental laws in South Africa before we go to the sector-specific environmental legislation that are available in South Africa. These addresses environmental requirements in terms of air quality, in terms of waste management, and in terms of water resources. Summarizing the Constitution of South Africa and its Bill of Rights, Section 24 of the Constitution really provides that everyone has a right to an environment that is not harmful to their health or well-being. The environment must be protected for the benefit of current and future generations through reasonable legislative and other measures to prevent pollution, promote conservation, and more importantly, secure sustainable development and use of natural resources while promoting justifiable economic and social development. And that last bullet point, B2, is quite critical because one needs to balance development and limit impact on the environment. And that's why we have the process of environmental impact assessments and environmental authorizations prior to projects being started in South Africa. I'm going to substantiate this particular right with the various principles that are used in South Africa. The first one being the polluter pays principle, basically saying that whoever is responsible for pollution or environmental damage must pay for the cost to repair the environment, pay for the cost to address human health impacts, prevent further pollution, further damage to the environment, and to reduce air pollution. I think we have all seen this in play in many countries in the world where we found fuel tankers running aground and causing ecological damage in the marine environment. The countries normally go against the operator or the contractor running the fuel tanker, but also take it all the way to the owner of the fuel being transported or the investors behind the item being transported at sea. And similarly on land in South Africa, the polluter pays principle applies. The other principle is one that talks about cradle to grave. So basically in summary, it talks about the fact that one is responsible for the product or the service from an environmental and health and safety perspective from the beginning, from the conceptualization of that particular product or service throughout all its stages to the point of disposal of the product and the waste that may come from it, or if it's a infrastructure or a mine or a factory, to the point where it's been decommissioned and there's a need to rehabilitate the area where it was. A strange example these days that's coming throughout the world is the use of the disposable face masks, as we all have seen. It's said that they are causing a lot of pollution in the marine environment, the disposable mask that we all need to wear. And therefore the producers have now changed tact by starting to design and produce reusable masks in order to minimize the impact on the environment from disposable masks, because there's tons and tons of such masks being disposed irresponsibly throughout the world. And again, if you have a contractor working with you from a project, or a product or a process, they need to be aware that you as a client remain responsible from the moment you start with the concept, you design, you manufacture or produce, the product is being used, and once it's being discarded, you still remain responsible. You find again on the electronic waste from computers, etc., that as long as they have that label of your company, could be, and I won't mention names here, but whoever produces the particular computer, that name remains with the item, and they are deemed to be responsible for how it's being disposed of in a responsible manner. I've got an example here of the principle of cradle to grave that you can perhaps look at. Let's say, for example, you have in your operation a mine, office block, hospital, or wherever, you have 5 210-liter drums full of fluorescent tubes, which are deemed to be hazardous. That's why they've got a big H. And obviously, you're not the one to get rid of them, but you need to find someone to transport them and get rid of them in a responsible manner. So whoever you contract out to transport them, you need to ensure that they are registered locally and within the provincial bylaws. They comply with the Road Traffic Act as they transport the waste. This could be medical waste as well, or just general waste. You remain the consigner or the generator of the waste, so you still are associated with the waste, even though it is now in the hands of a transporter. You need to ensure that they give you a waste manifest document, and it will help if you know, or you have weighed the waste at your own site prior to giving it off to the transporter by taking your truck through the weigh bridge. And then make sure that the transporter has got all the licenses and provides regular information to you and the regulators about the waste volumes and type as required by law, and ultimately provide you with a certificate of safe disposal. There are many regulations attached to waste management in South Africa that really should form part of your contract agreement with the transporter, so that the cradle to grave principle is being adhered to, and you avoid being caught out by the polluter pays principle. You will do this by checking on your transporter, by conducting surprise audits, and also checking that they are using the most direct route and there are no incidents that they're involved in. And if they are, they report to you and to the regulators, and they take the least risk route. It will help you if they are certified and they can demonstrate environmentally sound practices as they transport the waste for you to the waste disposal site, which also must be licensed, and you are responsible for ensuring that your waste goes to a licensed site. It is not the job of the contractor, so you need to work closely with your contractors on this in this regard. I'm going to skip this slide, and as well as this one. This one basically, it's a take home for all of you. It is basically a summary process flow diagram of how one should engage contractors through the various stages, all the way to what you do if you can't find the appropriate one. And if you have found a contractor, what requirements are required, including the permit to work, as well as them being on your site. So this is really a summary of the procedure for managing contractors in various sites. And I'm sharing it with you to either check against your current procedures to improve or add on to it. And I'm not going to go through it to avoid wasting more time today. But it's there for you to investigate and interrogate and improve upon. and you're welcome to adopt it. In conclusion, really, I'm going to say that you do need to, at the end of the contract period with the contracting firm, review their EHS performance by now compiling your various inspections. And if they've been involved in incidents, you've investigated incidents with them, what findings you came across, what sanctions, if any, were issued against the contract employees or the company. Provide this in a written report, and then keep it for your own company so that sourcing department knows whether to use the particular firm of contractors or not in the future, or share it with the industry association to say company A is a good contractor, they are up there in terms of best practice, or should be blacklisted if we have sufficient grounds to do so and sufficient authority to do so. But most importantly, it would be useful to the contractor that you issue them with a written testimonial in terms of a service record that includes not just the technical aspects of how they did the work in terms of quality, costs, and the schedule, but also from an EHS perspective. You issue this to the contractor so they can use it as a reference document going forward, but also keep it for yourselves, because you may find that in the following winter period, you may again need to use the same or not to use the same contractor. And I'm going to stop my presentation in this juncture and open the floor for comments, questions, and other insights really in terms of what people have found useful in managing contractors in the various industries we all come from. Thank you.
Well, thank you very much, Sia. Like what Sia said, it's open for discussion. Before I put much more of my comments, I would like to just run out what Sia was taking us through. Sia was taking us through the management of contractors. He gave us a summary of contractors management process, the client responsibility in contractor management, high risk activities. He also went on to give us a typical contractors environmental health and safety file, planning, appointing of contractors, work execution, legal framework, and this legal framework was based on South African legal framework, and I believe wherever we are in our nations or even globally, we have different frameworks that govern our operation in construction, mining, or obviously in sea works. They also provide those legal frameworks, the good examples of South African legal framework, and also conclude. Now we open up the discussion. We found that this is very informative and good discussion that has been brought by Sia. We all welcome the discussion, and remember our discussion is open. As we tap on our microphone, raise up our hands to contribute, and also need to use our chat section to continue the discussion. Thank you, everybody. Is anyone have any contribution towards all right, thank you very much. Tendai, I can see your hand is raised. You have the audience.
Thanks, Sia. That was quite insightful and informative. What I just wanted to add, or to comment, not really to add, is that in other areas, like where I have been involved, in terms of the framework, like the one of the few last slides that you presented on the summary of the processes, what we have done here is exactly that one. So what we have done on that one, we've kind of identified what are the pre-contract activities, stepwise, up to the award of the contract, and what are the post award activities. I think it's also there in this in the slide that you presented, but I've seen that it helps us a lot, especially when it comes to monitoring and ensuring that all the steps have been covered. But I think it's almost similar to what you have presented. But on the post award, just before execution, there's another step that we take, which is like an HSC or a EHS workshop, where the contractor takes us through their scope and their risk assessment. The reason why we do this is that sometimes people provide their scope of work and their risk assessments on paper, but when you get to talk to them, you find that there are gaps. They probably do not really understand what they wrote in their risk assessments. And because sometimes, I think Sia, you would agree with me that we have a lot of consultants in South Africa. So people go to consultants, they prepare risk assessments and other related documents for them. But the people who are actually carrying out the task or the project, they don't really understand what is in the documents. So we go through. The idea is not to cash them out, but just to get the assurance that they know what they are going to be doing and they understand the level of risk involved and how to manage it. So usually we do, depending on the complexity of and size of the project, it's usually a one-day workshop, or sometimes it stretches to 2 days because some of the projects are really massive. Yeah, so that's the other thing that I just wanted to add. And then when we verify all the requirements are in place, like you said, we also issue what we call a commencement certificate. So they cannot start before certain activities are in place. And this includes their audits. If they have to put up an accommodation camp, you inspect their camp, if it's okay, their industrial yard where they do fabrications and all those things. So before these things are approved, they cannot get that commencement certificate and they cannot start. And then the other thing I wanted to add to this discussion was that in most organizations, I've realized that if contractors are going to be involved in complex activities, our pre-qualification does not look at the competencies of the contractor in terms of managing CMOPs, which normally most organizations, they only find out, during execution, that the contractor does not understand how to manage CMOPs or concurrent operations sometimes. Sia, you mentioned that the client, we need to make sure that if there are concurrent operations and we have multiple contractors, we need to manage that. But sometimes it is also good before the contractors come to check whether they have prior experience and they have competencies in managing those areas, which is very important. And then my last contribution, which sometimes is controversial, we talked about single source suppliers and the risk related to that. What we have done here is that in order to manage that risk, before we even award the contract, we have 3 modes of contracts. So there's what we call mode 1 and mode 2 and mode 3. The difference is that, like in mode 1, the contractor applies the client's HSE management system, but they're also required to have their own management system. But in terms of application, they use the client's HSE management system. In contractor mode 2, the contractor is allowed to use their own HSE management system, but they still report the key performance indicators to the client. And then the last one is what Sia mentioned earlier on, which we call the mode 3. Mode 3 mostly is the guys who are providing services, like your DHLs. So they come, they deliver, and their vehicle breaks down on site. What do you do? So we actually, we have put them in mode 3. So we know in advance how to manage them. And they also know at the time of signing the contract what they can do and what they cannot do. This is where the client, they have their own HSE management system. They don't report their statistics to you, okay? But when they're on site, they conform to what we expect. To be more practical, the challenges that normally come with these kind of suppliers in mode 3. In South Africa, for example, I know there's an organization. Obviously, we don't mention names here. Yes, they are a supplier, but they have a supplier monopoly. They supply a certain product, which is very important for operations. But the problem is they also have their equipment inside. So they have to do maintenance of their equipment. And sometimes if you want, to extend your capacity, let's just assume it's supply of gas, natural gas, for argument's sake. They have the monopoly to supply. Okay, and still they have to work within your premises. So how do you handle that? Depending, on the supplier, some of them could be stubborn because they know that there's nothing much you can do to them. So these are what we call, you need to be aware of such scenarios because they will happen on the ground, not because the supplier is a company. That's their culture, but it depends on the individuals that you are dealing with. So in advance, you need to make sure that you have identified the risk associated with such suppliers of services or products who have this kind of monopolies. Otherwise, yeah, sorry, I think I've taken a lot of time, but these are the things that I picked throughout the presentation that I thought I could also share with the rest of the team. Thank you.
Yeah, well, thank you very much, Tendai Kachikamadare, for your contribution. Earlier on, before we started the session, one of our registrants also asked a question that is, what best practices have you learned on contractor management during the COVID-19 pandemic? So I'm going to pose up this question to everybody. If anybody have an experience with the contractors or to anyone, then we can answer and get the answer for that. All right, I can see Fungai Mpunga, your hand is up.
Okay, thank you, Chine. Thank you, Sia, for quite an informative presentation, and thank you, Tendai, also for adding on those comments. I'll speak on the COVID, but after just make a few comments on the previous. I think it's fair to say that the more preparation that's done before contractors come on site, whether it be in terms of inductions, understanding the EHS systems that are used by the client and so on, I think the less there is a risk or potential for deviation from expectations, and also, of course, the occurrence of incidents. But I think what I tend to also to observe, and I'll be interested to get feedback from you, Sia, in that it's well and good for us to do the preparation and to go through the processes and we put it in the contracts. But when we come onto site, things tend to change. Even the client themselves, sometimes they are found wanting in terms of application of their own systems. And then we execute the work that needs to be done. But after the work is done, everything seems to be a big rush. That after action review tends to be quite lacking. This is my observation. I don't know what your experience has been. In terms of COVID, yeah, that's been interesting. I think fair to say, I think in my opinion, we've all been learning. Everything is relatively new. Even at home, we've got this homeschooling and online learning, something that, in the past there was distance education, but now it's gone to a whole new level with even primary school going through the same. And I think that adaptability has been varied across industry, having had the opportunity to work on various sites. whereby, the fact that everyone's learning, you find even at an individual level, acceptance of the fact that, some people even argue on the existence of COVID. And I think many of us have been caught wanting, where we were not quick enough to adjust. But I think fair to say now, everyone is taking it seriously, or most companies are taking it seriously. Thank you.
Okay, thanks Fungai, and also thanks to Nai earlier on with his insights. Okay, so I was trying to respond to Fungai's question in terms of the experience that once all things are done and work is supposed to be executed, perhaps even the client drops the ball in not focusing on contractors as they should. That is true at times, and it attests to the effectiveness of the client's health and safety system, because contractors are at times a big portion of the client's overall business. And if they fail to have systems in place to manage them, it is telling when you look at the safety stats, because you can indicate the incidents of either rework or incidents of injuries on duty or near misses. And if you trace where they are coming from, and you see that most of the time it is the contractor employees who are affected or who have been the cause of such incidents. So that's where you read the lack of attention. But those are lagging indicators, as you all know. So it's after the fact. So what in my experience has been found to work is it's taking first the comment from Tendai. That commencement certificate is very crucial, because it gives you some assurance and confidence on the company you are appointing on site. But you also as a client need to have perhaps a dedicated office for managing contractors. And you need to have the resources in that office, from an administrator to an EHS officer to an environmental officer that specifically focuses on contractor companies. If you are a firm or an operator that has regular contractors or has multiple contractors on site, it helps to have a dedicated office for managing contractors. Obviously, it needs to report through the EHS department of the company. And the other key tool that we have found to be useful is a permit to work system. Now, this one addresses the issue of concurrent activities, where you can stagger the various activities by requesting that the permit needs to be issued before critical work commences. And that permit to work needs to be approved or signed off by the owners of the area. So if in a smelter there's a furnace 1, the manager of that furnace needs to approve the work to be done by a contractor. Or if it's a manufacturing site, workshop A manager needs to approve such a permit. And that way your contractors don't work in parallel to your regular or standard operations, but they form part of the company's overall business by having a permit to work system in place. Because at times you may stop or reschedule some work either of the company or of the various contractors in order to minimize risk. The key thing is that the work needs to be owned by a technical supervisor or manager that is accountable for the work area or section of the company over and above the EHS department. And then regular meetings also are important, because you can't leave contractors on their own. They also get frustrated by internal systems of the company where they get stopped from doing the work, or they get harassed by internal employees. So if you allow them a platform where they can raise their grievances and address them proactively, it may smoothen the way contract work together with your own core business managers.
Thank you very much, Sia, for the response to Fungai Mpunga's question. Well, I would like to thank everyone for making this 14th episode a success. Your presence makes it a success, and I would like to thank Sia for that informative presentation. I would like to thank you very much. I will allow everybody to move on towards the end of this presentation that we have. So you allow me to share my slides. Thank you very much. Our guest presenter is Linga Magada. She will be presenting on managing the COVID-19 infodemic in workplaces. That is going to be held on this coming Friday on 3 September, same time, 9 to 11, to engage us in WhatsApp platforms and different social media platforms. You can join our WhatsApp group on the numbers shared on the screen. And you can also email us on esh.africa. The email shared on the screen. You can also get in touch with us on our website that is also shared on the screen. I would like to notify everybody that we have our magazine that has been launched, the August magazine that has been launched this August, that is Women in Safety forms through our website, or you can email us and we can send you up the link, or you can scan our QR code showed on the screen. You can also get in touch with us on the email address provided on the screen, on where you want to advertise your products through our magazine. You can engage us through the email or the phone numbers provided so that you can feature up in our magazine. Please note that it is quite open for everybody to send up your articles, your adverts, and to share your story within our magazine. We can publish for you and make a success story in Africa. As we move to the end of this discussion, if you can check on the chat section, we have provided the links to download or to read our magazine online that you can access on that. So I will allow everybody to share your screen, your videos, and turn on your videos.